Thank you to the organizers for inviting me to speak here today and for organizing this timely event. This month marks 10 years since the massacre of Lampedusa. On 3rd October 2013, a boat carrying mostly Eritrean refugees sank off the coast of Lampedusa, Italy, resulting in at least 368 deaths. Similar events have since frequently repeated in the Mediterranean Sea. Some commentators have actually made an analogy between the contemporary Lampedusa tragedies and the slave ship. However, as much as current events may be evocative of the past, this doesn't mean that slavery is confined to the past or to memory. Thousands of Eritrea, in fact, flee slavery in Eritrea every month. Following a 2-year-long investigation, in its final report of 2016, the UN Commission of Inquiry on Human Rights in Eritrea made positive findings on slavery in the country. It found that under the military national service program in the country, Eritrean officials subject conscripts to slavery within the meaning of international law. The Commission also found that slavery and other human rights abuses, including torture, are committed as part of widespread or systematic attack against the civilian population, and therefore reach the threshold of a crime against humanity under the Rome Statute. Apart from the Commission of Inquiry on Eritrea, country reports on Eritrea by, for instance, international organizations, UN and EU agencies and governments have made no attempt, perhaps conveniently, to assess whether or not the national service qualifies as slavery. Instead, they focus on assessing it as forced labor, which, although not mutually exclusive, there are two different legal categories. While forced labor allows for exceptions and the protection from it can be derogated in time of emergency, slavery does and cannot. Or oversimplistically label it as modern slavery, which means everything and nothing, is not a legal term, and problematically contributes to the erroneous belief that the slavery only belongs to the past. Other reports just simply remain silent on the topic. It is important that slavery is recognized as slavery and termed as such when it occurs, not watered down by terms such as modern slavery or construed as a different legal category based on incorrect interpretations. And this is what my research is about. It counterbalances the mainstream, as the widespread misunderstanding of what slavery is and how it manifests in a contemporary setting such as Eritrea is increasingly used or misused by asylum courts in Europe to unduly deny refugee status to Eritrean applicants. And this is particularly the case in Germany and Switzerland, where governmental policies and judgments by asylum courts there have reduced access to refugee status to a bare minimum for Eritreans, rejecting that the military national service in the country, by citing each other with approval, could be considered to be slavery or forced labor, as, in their view, it has to be understood in the context of, and I quote, the Eritrean socialist economic system based on self-reliance. The Higher Administrative Court of Hamburg and the Administrative Court of Gießen go as far as to rule that the national service in Eritrea is a normal civic obligation, which is actually one of the permitted exceptions to forced labor, arguing that, and I quote, it serves the general interest and social solidarity, by comparing national service in Eritrea with compulsory fire service in Germany in cases where there are not enough volunteers. I think we can all agree that this greatly differs from the obligation to perform national service in Eritrea in arbitrary conditions, under pain of severe punishment and for an indefinite period. The change of practice towards Eritrean asylum applications in Germany dates back to 2016. Until then, most Eritreans were granted refugee status in the country. The Germany change of practice and policy shift coincides with an official visit of Eritrean authorities to Germany in early 2016. The visit was aimed at fostering bilateral ties and attracting investment in various sectors in Eritrea. A few months after, in November 2016, Eritrea and the International Fund for Agricultural Development signed a financial agreement to boost coastal and inland fisheries. And Germany is the only country among the international co-financiers. It has contributed so far $11.55 million. Actually, Eritrea traditionally exports fish to Germany, among other European countries. Fishermen in Eritrea are subject to national service and therefore are slaves. National service extends to all sectors in Eritrea, public and private. It was not long ago that the EU was subjected to wide criticism for funding slave labor in construction sites in Eritrea through the EU Emergency Trust Fund for Africa. Funding something that is in breach of human rights contravenes EU and international law, and most probably many national constitutions of EU member states. The question that I pose to this institution and its member is, could it be that Germany and its fellow EU member states, as well as EU institutions, are reluctant to consider Eritrea's national service to be slavery because they are benefiting from it? Thank you.